We have been batchmates in Amity Law School. And what are you doing now currently?
Yes. So currently, I've been working with the JK organization, not division, and I've been working with them as a legal counsel. Presently, the work more or less revolves around litigation plus corporate. And apart from that, in my part time, what I've been really struggling with. So I have a YouTube channel of my own as well, which goes by
What
the
is
name
it
of
about?
Legally. So it goes by the name of Legally with Vishal. But then I've been very active with it. But presently, no, I haven't been active. I'll tell you why. I've been looking with the aspect of what do I need to bring in my YouTube channel, because let's face it, today people need to know more and more about their rights, as more and more rights of theirs are being infringed. When I talk about those, let's talk about a normal aspect. You and me, we've been a consumer day in and day out. So what I really need is to be, telling people what their rights are as a consumer, and telling them how do they approach a normal police person or personal going to the police station, what rights do they have. So just in and out of basic rights. I'm not going to go too much into what the CRPC says or what the criminal procedure code, civil procedure code says, because let's face it, normal people do not want to even indulge into these many problems or laws. Let's just face it, normal layman doesn't even want to know what section says what, but they just want to know what the rights are. So that's what I've been doing with the channel, and currently that's pretty much summed it up, buddy.
It's such a good initiative you're taking.
Thanks,
can you just put your microphone just a little closer, because the voice is disconnecting a little.
Is it better now?
The microphone.
Okay.
Earbuds, yeah. Okay, so the topic that we have touched upon today, that we will touch upon today, is contract law, right? So in your own basic words, what is contract?
So as a legal person or as a law student, when you were studying law in our 5 years course, contract was the first and foremost subject that we came across. And it's the most basic subject that we study in law. It's basic yet the most important to say, because let's say today, if I go on to even buy any consumer goods or any goods for the matter of fact, I enter into an agreement, right, where there's an offer and there's an acceptance. So to question that you raised, that is what is a contract, I just answer to you that it's just an agreement which becomes a contract enforceable by law. So when a law comes into picture and it enforces what the two parties have understood and are in agreement, that is what makes a contract. So it's a very, very important procedure and subject that we study throughout our 5 years of law. And to be honest, I love contracts, and that's why I've accepted your thing to come here and talk about contracts today. So really looking forward to it.
Okay, so just like your YouTube channel, why do you think contract law should be studied by people who are lay people, who are not into law? Why is it relevant to them?
Right. So I feel like for every layman, what you really, really need is just an understanding about how your rights go. If you sign a paper, or if you just come into a mutual understanding and an agreement between a person, your obligation does not end over there. In fact, it starts from there when you sign the paper. Right? You sign the paper, your obligations come into picture, and from now on you're binded by something. So you know how your obligations would go on, what your things are going to be that's going to follow. If a particular act cannot be done by either of the parties or people who've come into the agreement or contract, what do? You know that if something cannot be done, there is another alternative that can come into picture. You need to make an agreement in a way that it safeguards you. If it does not, you know that there is always going to be dispute resolution clause or other clauses in the contract which is going to safeguard you. Coming back to your question, why do people need to know about contracts? Is because, like I've rightly pointed out in the first question itself, everyone gets into the most normal thing, and that is offer and acceptance. The contract is nothing but starts with offer and then acceptance. So if you, for example, throw something at me which is an offer, just and I go on to accept the same, we bind it, and it is enforceable by law, then it becomes a contract, right? So for a fact that this is just a starting. You need to pen it down on a paper, right? Which then goes on to govern both the parties. So that when you go in the future, this is going to bind you. and henceforth you need to pen it down in such a way that it helps you in the future, or when the contract becomes effective, till the date it is effective. So I think like normal laymen should know it, because you come across these offer and acceptance and things in a day-to-day life.
So can you like tell the viewers why is it so important to read the contract before signing it?
Right. So we've come across hefty people. In fact, let's just say I have done it too. When we just come across an app which tells us to read a terms and condition, and just in a hurry, we do not even read the first paragraph. We just go on to just accept the terms and conditions and just go ahead with it. Right. But then why is it important? I'll tell you why. You, for a matter of fact, just buy something. You did not know what the terms and conditions of the same license or same goods were, right? When you were accepting the same. Uh, 4 months later, 5 months later, you do not have a clue what could happen with the same object that you've taken. It goes wrong. If something goes wrong, and then as and when you actually purchase that product, you were basically in a agreement, right? So when you knew what the terms and conditions of that thing were, of the product or the purchase that you've done, you can very well go on to the other party and say, hey buddy, listen, this is the problem that I faced, and you, for a fact, that are responsible to replace or refund me for the same, because this is the problem which has been caused by your negligence or whatever the situation may be. So that is why it is important for everyone to read what the understanding is, or whatever has been penned down by them, by the party who's giving you a product, or either parties, in fact, when they're coming into an agreement. So contract terms are very, very vital. So for a fact that you must have come across a lot of people now saying, what, arbitration has been really, really booming in India. Why is it booming in India? Because every contract for these days, I'm not just saying for services, but every more or less contract these days has a dispute resolution clause, right? And which goes on to say that if both the parties have any dispute arising from this contract, they can very well go to have an arbitration done and appoint an arbitrator, and then they can go on to settle their claims in front of the arbitrator. So these are coming all out of contracts, and that is why it is essential.
Is that clause added to save time about arbitration?
It's actually added for you to get your dispute settled outside court without not a lot of hassle. Because let's just face it, as much as I am a lawyer, I can tell you, you do not make a lot of sense when you go to the court for a very minute matter. For example, if you purchase something which is just worth $1,000, let's just face it, you're facing another problem if you go to the court for just $1,000. It's gonna consume more time and more energy and more money of yours than to just settle the dispute outside.
Right. Okay.
It's way better. You do read your clauses, and then it's just normal layman thing. That's why you hire a lawyer. They read the things for you, because you cannot read what things are written in the clauses or the agreement that you enter into, right? So that's all. You as a layman need not maybe read it, give it to your advocate, please, but do read what it's written when you're signing, because you will be bounded by it.
And hiring an attorney and giving him some money will save you money in the long run, right? Especially when you're in a business, right?
Yes. It might actually save you a lot of money. It might not. I'll tell you why. Right. If your actually goods are just worth $1,000, or let's just say $5,000, you're gonna have a lot of expenditure later on. This is also the reason why a lot of people do not institute a civil suit or recovery suit, because they know, listen, buddy, I'm not gonna pay you $20,000 to recover 5,000. Let's be practical. There's gonna be no profit out of this. Right. So that's the reason why nobody gets into all the cases and civil suits being filed every day. But yet the condition is today as such that we still have a lot of cases pending.
Right. So what is the difference between agreement and contract?
Right. So this is a very good question. I'll tell you why. Because both these words are synonymously used.
Right.
They're used interchangeably, and when you ask most of the people, they would go clueless about it. Right. An agreement can be mutually understanding of two people coming together for a term sheet. A term sheet being made, like the word goes, agreement. It's basically just two people agreeing to something. So it can be an agreement whereby you have two people coming together signing just a mutual term sheet that is being filed. So you can pen it down on a piece of paper, telling each other that this is what we've made, and you might not be bounded by it because it might not be enforceable, but this is what we have come to a conclusion, and this is what our agreement is, right? When we talk about a contract, it's basically enforceable by law. It's a total enforceable by law, and hence you might have heard the term that all agreements may not be contract, but all contracts are agreement.
Right.
We've used this term in very interchangeably when we were budding lawyers in the first year, second year. We thought what agreement and contracts are, let's say, the same word, right? Even today I would say this, we use it as the same word,
right?
So yeah.
So what elements need to be constituted to make a contract?
Okay, so I am going to answer this in a way by saying, you tell me what you want in a contract. I'll tell you why I'm asking you this. Because if you're entering into a service contract, or let's say a software agreement contract or something like that, where you have a consideration which is different than just goods or goods being purchased or something like that, it has to have those clauses. The contract really depends upon what you're getting into. If you're getting into buying a software from another party, your clauses are going to be like that. Yet there are some clauses which remain the same every time. I'll tell you what will be those. Dispute resolution stays the same. It's going to be there depending on where you want your court jurisdiction to be, or where the agreement has been signed and where the parties want the court jurisdiction to be. And other than that, there'll be reps and warranties that the both parties should provide, and there should be indemnity being provided by the party, right? There will be a normal consideration either way, right? Because there is no contract without consideration.
Can you explain consideration? It confuses a lot of law students.
I will tell you what it means. So let's just say, Akash, you gave me 500 bucks, and I'll tell you that I'll get you the 1 liter of petrol for your bike. So over here, for me, consideration is the 500 bucks, right? Or the 500 money that you're giving me. And for you, the other thing is, for 500 bucks, you're getting the 1 liter petrol. Right. Unless it is illegal, you are in a contract. Per se, it should not be illegal, but then you are in a contract till the time there is a consideration. There is no if there's no consideration, there's no contract. Let's just go on to say this.
If I have a daughter and I give her my property out of love and affection, that's an exception, right, to consideration?
Okay, so then we are basically now not governed by contract. This is not contract. When you say this then comes under family law, then there will be gift. That is another topic altogether that we can discuss. But then there is this is a whole different topic that we can discuss. Then that is not a contract. I'll tell you what, another example of a contract consideration can be just a normal thing. There you go on to say that we are entering into a software agreement whereby your company will be providing me the software for me to function, for my team to function, and in replacement of that, and in replica of that, what we're going to do for you is we're going to provide you with 5 lakhs. For me, the software is the consideration, right? And for you, it's the 5 lakhs, and vice versa, right? So that's the consideration for you. There are various types of contracts that you enter into. By various, I mean different kinds. One can enter into an employment contract. There will be another one could be like I just mentioned, software contract. There could be another one which is as simple as just services contract, which means nothing but just you providing a simple service. So
and the value of the consideration shouldn't matter. I give you 1 pen, you give me 100 liters of petrol. It still makes sense, right? For the law.
If the parties agree to it, I mean, yes, that's not a problem. Because there are cases which goes on to say, what, you can't just have 1 rupee to be given when you're having to the other person a lot bigger thing that is given, right? But then there are also plethora, and I mean plethora of cases which goes on to say, unless that is consideration, we're not going to rule out this option.
Right.
So consideration is a must, is what we're going to say over here.
Okay. So speaking about illegal, can I come into a contract for you to murder someone?
Right. No, you can't. So I'll tell you why. Because just 2 questions back, I told you your contract is something which is only only something which is enforceable in law or by law, right? Murder is per se nothing which can be enforced by law. In fact, it can get you into the bar, definitely behind the bars. So it's not something that you can get into a contract for. But these contracts also are ab initio void because they're illegal.
We'll come to void and voidable, ab initio void. Right.
Yes.
Okay. So let's say we come into a legal, all contracts are legal. We come into a contract and you fail to perform your duties. So what recourse can I have?
So if I fail to perform my duties, like I said, you are then going to be governed by the other clauses of the contract.
Right.
That is,
I have no alternate clause.
Or you have no alternative clause. Great, then you must be having a dispute resolution clause in that case. Where your advocate went on to draft it in a certain manner, where you had a dispute resolution clause which said you can have a mediation or you can have a arbitration, really depending upon what the contract goes on to be. Right. If it's a normal contract, you can have a mediation when both the parties agree to the understanding that I'll give you another 90 days, you make me good for what has not been done by you, and forwarding which or going further, if that is done, you are then again in the contract. There's no problem to which. But if then it is again not being fulfilled per se, it is a avoidable contract. Right. You can go on to say that, boss, listen, this is not going to be fulfilled by me from my side, at least because you have on your part not done the duty. Right. So I'm not going to be bound by it. In fact, you can go on to terminate the whole contract. That now depends upon the termination clause. So termination clause is then again a very vital aspect which has to be covered in all the contracts. How do you terminate a contract when you know that there has been no discrepancy on the part of the other party in not fulfilling their obligations? How do you go on to terminate? So if you know that there's a termination clause, you can very well go on to terminate the contract.
Okay. So what defenses can you take?
But again, this is just about how you get into a voidable one. Right? Avoidable is something which per se is void, but totally depends upon the other party when they want to get out of it. A void contract would be when it is per se, or let's just say void.
It is not even a contract.
Yes, it is not even a contract. So let's say you say that two people below the age of 18 they get married. Okay. That's not something that is a very valid contract. Like I said, not even enforced by law. It is void in nature. Right? And this is a contract being done by both their family members. That they're going to get their son, daughter married. This is not enforceable by law. The family members are getting into an agreement which is going to be void ab initio.
And can you give an example of voidable contract?
Voidable would be, I'll tell you what, this just came into my mind right now. So I'll tell you what voidable would be when I tell you, it can have the party deciding if they want to terminate or not that particular contract. The full will is upon a party to terminate the contract. Right? They can go on to have a contract even when they know that this is something that is not a very valid ground. They can still go on to have a contract. Right? But the other party has the very will and can go on to terminate a contract knowing that there's this element which is come into which is not per se very legal.
Right.
If they want to agree, it's valid. If they but they have an option of terminating it, right? Because they have found something element which is not per se very valid. So that becomes a very voidable contract.
So coming back to breach of contract, what are some of the valid defenses that you can take which the court will accept?
Okay. Breach of contracts is a very interesting topic. I'll tell you what we studied about what makes an agreement or contract, in breach. What if I tell you that two people entered into a contract and one of them was intoxicated or was under the you know uh, under alcoholic influence or was not under control. He was under insanity. Right? There's various clauses that come into picture when you sign an agreement under these circumstances. So your clause, then the agreement or the contract then goes on to be a toto voidable contract. Right? Like I told you before this, voidable can be when you know that the other person might have signed this when he was toxic or intoxic, sorry. So, and then you still go on to make that agreement very signable. You go on to have the obligations fulfilled. Meanwhile, you knew it. So it is a voidable thing over there.
By
Right?
the party who was intoxicated.
No. So the other party might have known that the other person, while they were signing, were actually under the influence of alcohol. So they might not have the full senses when they were signing the contract. Right? They very well knew about it, but they did not mean to say that we're not going to enter into this. You had the knowledge, but you still said you're going to continue with the contract.
So who can
That
terminate
means
the
that
contract?
the other person can very well.
Intoxicated.
Yes,
Those
the other
second one.
person.
Right.
In fact, I'll tell you what, both the people have the liberty over here to say, you know what, this is a voidable one because me who signed the contract was intoxicated, right? The other person who knew that the other person was intoxicated, both can. I'll tell you why, because they knew the circumstances, but they still went ahead with it, right? So then that becomes a binding one. Because even when you knew the circumstances, you're bringing this up after 5 years, 4 years, you knew the circumstances, everything has been followed throughout. So then that's not a problem. Although
If I
that
put a
this can be
gun,
something proved, then that's
right.
totally a that is to be come.
That
That will come
so
years later when dispute arises.
Right.
So
If I
yes.
put a gun to someone's head and tell them to sign the contract, so can they take the defense of breach of contract?
I'll tell you what they take a defense of. They were induced, in fact, to do
Coercion.
something which they never wanted to. Right? They were coerced, in fact, right? To do something they never wanted to. They can very well take a ground of defense over here. So that's not valid. Right? You're making someone do what they did not want to. So that is what comes into picture over here, and I think it's very normal for people to not understand contracts. But this is how we think we should make people understand contract. I'll tell you why. Because let's just not go into sections and other things. People for laymen, there are two big things that they don't want to understand. What layman wants to know is, boss, can I sign this agreement or contract? Because just tell me if I have the right to, if this agreement or contract is voidable, void, whatever. Just tell me in brief. I don't want to get into the nitty-gritties. Just tell me if I can do this. Right? If you're saying that you have rightly pointed out, if someone actually pointed a gun at me and told me to sign a contract, I am in full right to go and tell that later on this is not binding on me, because hey, this was the condition previously that I was made the contract being signed on. It's now totally depends upon you how you tell the court when this goes to the court, and if this goes to the court, that how and what was the circumstance that you were made to sign this in, right? And depending upon, this was a totally coercion, right, that you were made to sign a contract. If not, then it is totally a valid contract. If there's nothing of that sort, both the parties have signed it, it's a proper valid contract.
Right. Okay. So what is non-disclosure agreement?
All right. So I'll tell you why and what goes into making an NDA. Right, you must have come across this term, non-disclosure agreement or non-disclosure contract. There's now coming up coming up terms such as confidentiality agreement.
Right.
Why do these things come up? I'll tell you my personal experience. So I was joining JK in September, and while I was joining it, there was a good what 5 or 6 paras which were written while I signed that contract, which said, you know what, you cannot. And in fact, any of the contracts that any employee sign, there is a NDA being signed of what you do over here shall not be disclosed to the outside people. Right? Why do every organization want this? because they do not want that the place that you're working in, their information be go into the normal general public, because that's going to impact the working of one organization brutally. Because if for example, working in MRF, that is the Madras Rubber Factory company of tires, goes on to tell everyone in the public that hey, this is what they're thinking, they're going to come up with this in the future, that's going to impact the prices and everything
Definitely.
in the future. So that's going to really hamper the making and the thinking of the company, right? And then there goes also to be another aspect of you having insider trading in that case. That's why you also sign an NDA. So I'll tell you why the aspect of insider trading comes into picture. If your entity is or not, maybe not listed, right? You may not be listed, but then if you go on to say people, you know what, I am thinking this is what my company is doing, this is what they're doing, you must, right, invest in these ABCD companies, right? You saying this because your organization or ABC organization worked in something, right? You have something of any sort of knowledge which is then going on to be distributed to other people, right? And yet you signed an NDA. You're in much bigger, breach of what you signed, buddy, because you've then go on to tell people what shouldn't have been done. So that is what an NDA is. An NDA, when you even spell it out for people, it's a non-disclosure agreement you sign. It's a non-disclosure contract you sign, which specifically actually says non-disclosure. So keep your mouth shut. Do not go on to say everything that you do everywhere. Shout out to people that you've been working on these things. While every professional really need to follow NDAs, and that's the reason why you can only then go on to become something in your career. A lot of people, what they do is, and specifically advocates, they need to have this in picture, because advocates have this thing that they engaged with a lot of clients. You cannot go on to talk about your clients in public fora. You cannot,
without the
because
NDA
then,
also.
sorry,
Even without the NDA, you cannot talk
even
about your
without the NDA.
clients, right?
Yeah, because that's a client's confidentiality.
Yeah,
Right, that's a total client's confidentiality that
right,
you have with your clients. You cannot go on to discuss what they had discussed with you later on,
right.
right? Because then you are breaching their confidentiality, their privacy, and everything that has basically gone into picture. Why do you have this relation? Why do advocates have this relationship with their clients? Because they know whatever the clients tell them, it's not something that is to be shouted out in the public.
Right.
So that is again a good example of how NDA is, and even when it's not signed, for professionals like us who are advocates, we need to very well maintain it.
Right. Okay,
Yes,
so what is indemnity clause or contract?
right. So like I just mentioned, this is again a very important clause in your contract. Why do you want an indemnity clause? Say for example, Akash is selling me a plot of land.
Right.
You're selling me a plot of land for whatsoever consideration. Right. I know for a fact that I have done my due diligence on your land, that yes, it belongs to you. But tomorrow, if I go on to find out that hey, it was never Akash, but it belonged to someone, I need to have this indemnity when I'm entering this contract, that Akash is and will be responsible in case it is not his land.
Right.
Because I have been presented as if you were the owner of the land. Right. So I need an indemnity when I'm purchasing something that you show to be yours. Right. I may have done my due diligence, but I'm entering into a contract upon this understanding that you presented to me that it's your land. So I need this as an indemnity. And indemnity is nothing but you being safeguarded. Right. Both the parties can be safeguarded upon crucial aspects which they want to be. Like let's just say that in case of a software agreement, let's just talk about those. In case the software goes into a malware functioning, or something, virus malware happens, anything happens, right? And the software gets corrupted or something like that happens.
Right.
I want an indemnity in such a circumstance.
Hmm.
Right. Why will I be made sure? Why will I be borne the responsibility with when such a circumstance happens? So you need indemnity from such things. That is why the indemnity clause is very, very crucial.
Right. Okay.
Right.
Suppose we enter into a contract and something relevant to the contract, the circumstances revolving around it changes. Let's say an act of God happens that we could not foresee nor control. So, can the contract be voidable? What will happen?
So typically, I tell you what, after the corona pandemic, everyone has one thing in their
Right,
contract these days, that is
right.
force majeure. Nobody signs a contract these days without a force majeure clause in it.
Hmm,
And that really depends upon contract, to be honest, Akash, because you can go on to have a, just void contract, right?
hmm,
Because it was never even covered in your contract or something like that.
hmm,
That if such a circumstance happens, will you be responsible for showing or doing your services even in that circumstance? Right? If
hmm.
it isn't even covered in your contract, how are you going to be bounded by it? Right?
Right.
Let's just face it. It's not going to be even affecting you. Forget void or me saying void. It's not even going to affect you because you didn't even sign up for something
Hmm,
like that, right? But today, why people sign force majeure is because they've seen what the corona has done to people. Everything was taken back, nothing was working. In such a circumstance, everyone wants, that party come to a consensus. They both talk to each other, and what will be their course of action.
hmm,
So force majeure clause basically talks about, in such a circumstance, both the parties to understand and come to an understanding that, look, boss, this is how we're going to function in this scenario. We cannot do or work accordingly normally, as the scenario was previously. So what we're going to do is we're going to function according to this. This understanding might be when the parties come together and understand what has happened is wrong, because
hmm.
so and so has happened. In the corona, I remember I had made an agreement about this software agreement which was done between two companies, and the software agreement had the force majeure clause because they knew, work from home is something that they're going to really depend upon. So if something happens, they had typically written down that two people, both the parties are going to, the representative of both the parties are going to have a settled talk amongst them. They're going to
Hmm.
decide what's going to happen if something goes wrong in the software, because there's going to be a heavy load when everyone's working from home. So if anything happens within the software, between the whole
Right.
country being shut down, they're going to
Hmm,
settle their talks, have a discussion, and discuss their way forward.
hmm.
So that's
Okay.
that's what happened with the force majeure clause coming into the picture. Now everyone wants it because they know this is this is something that can not be
Right.
really out of your contract. Or let's just say something. I can tell you what, before 2020, I had not seen
Hmm,
force majeure clause in every contract. I can tell you this because there wasn't force majeure clause in every contract. There wasn't. After that, it's in every other contract. In fact, I'll tell
right.
you what, even the rent agreements now have a force majeure clause.
Okay.
Right.
Interesting. Last question I want to ask you, besides from act of God, what
Mhm.
other factors can terminate a contract?
Besides from
Act of God, what other ways can a contract be terminated automatically?
automatically. So I'll tell you what. When we talk about automatically,
Hmm,
you know that the other person has done something which is illegal per se.
hmm,
One. Second, they've not done their duty, or the thing that actually made the agreement go on. Right.
hmm,
The most basic premise was not
hmm.
followed. That is, consultation was not given in furtherance to the
Right,
contract. You have no contract in that circumstance because there
right,
was no offer and acceptance. There was no consideration that was given. Acceptance would only have been if you actually got what you would
right.
promised. Right.
I'm
That
asking
made
you that a contract is in existence and it is going
yes.
on, but due to
Mhm.
some reasons, it can be terminated. What are the reasons?
I'll tell you what. A,
Right,
illegal, anything illegal that comes into picture. Second, if I go on to tell you that basic promises which were the obligations of the parties were not fulfilled, you can go
right.
on to then terminate. And as the word that was used by you, automatic,
Hmm,
some contracts do not have automatic termination. They want the other party to be served with a notice, right, before they go on to terminate the contract. So, as and when and whatever the contract says, you have to abide by them. If there's a notice period, you will have to give the notice period to the other party that so and so
right.
obligation wasn't fulfilled by you. And now, boss, look, You've not done this. That's why we are sending you a notice within next 30 days or whatever the days have been prescribed in the contract. Your agreement or contract then goes out to be null and terminated. Right.
What if
So,
the
like I
other
said,
party dies or goes insane?
I'll tell you what. In such a circumstance, a lot of contracts say ABC, son of so, resident of so, right? Expression which shall mean his legal heir, assignees, and whoever other people legal representative would be. So in such a circumstance that one loses or whoever has signed the agreement or contract, who loses their legal capacity to do what they're doing, then it passes on to the legal representative, legal heirs. So it passes on to them. As you must have seen in many contracts, they use this change these days. When you even sign, let's just talk about a very basic agreement that you see, rent agreement. That goes on to say, let's see, the rent agreement is between the two of us. You've given me the flat, right? And I say, I was dead. That's it, right? My family members can still stay in that flat because it's not just me who you signed the agreement with, but it was also my legal heir and the representative, which includes my family.
So can you
So you
tell
just
us?
cannot, because I have died, you just cannot evict me.
Yeah. So when is your YouTube channel starting? The new concept that you're revamping.
Great that you asked. So I'm thinking of starting my YouTube channel again this week with, like I just mentioned in the start, couple of new things which I've thought about. The consumer aspect coming into picture. What I've also thought is getting people on board and just having small discussions as well. Because people today really have gone on board to have a look at what people are talking and discussing on news. Yet those are irrelevant talks. We need to today tell people what relevant talks look like, because that has gone for a toss, to be honest. People are looking at discussions and debates on news channels, and to be honest, those are not something that you really want to have a look at, because those are just nasty comments on each other and political comments that are just inspired by motives. We want to know what the law is, what people should have done, which could have safeguarded them, and what the law says. That's it. You just want to know that. You just do not want people ranting at each other. So that's what you're thinking about, getting people on board, discussing about legal aspects which have come into being these days, problems that people are facing. Let's just start off with, I had this in mind. Let's just start off with the most common thing. Can Russia go on to invade Ukraine with the UN and every international policy is being enforced? I mean, yes, they have. They already have. They've actually killed a lot of people over there. But the international policies and everything has gone for a toss. It looked like UN was a very powerful body, but present condition says that boss, there is no law. So sometimes I understand that the law also goes for a toss. Let's just face it. Let's just be practical. You cannot have law every time, but you can tell people what the laws were saying, right? Even in the present scenario, what did the law say and what was actually violated by the Russian forces or the country? So yeah, that's pretty much it. That's what we want from our YouTube channel, to be just basic discussion, just telling each other, hey Akash, this is what you should have done as a consumer, and you have this right. Do not go to the consumer forum, because let's just be practical. I want to just give you practical information. $500 is what you spend. Do not go to the forum. But if you spend 5 lakhs, please do. Right? Just practical discussion and feedback. That's what we want to give people. So yeah, I'm rolling out this week. Let's hope that we do.
All the best, man. And it was great talking to you.
Same here, Akash. Same here. Thank you so much.
I'll just stop the recording.
Sure, sure.